And we're live. Um, Hi, everybody. Thank you so much for joining us. This is the second in what we hope will become a series of Hangouts on current policy issues. We started Google Take Action to inform and engage Internet users on public policy issues that affect the Internet. We rely a lot on written communication, but we also think that conversation is really one of the best ways to learn. So today, we've invited two experts from civil society to talk about the exciting developments in Congress regarding surveillance law reform. We have Rainey Reitman of the Electronic Frontier Foundation and Robyn Greene of New America's Open Technology Institute. I'll first let them introduce themselves and talk a little bit about their organizations and their work before we dive into a discussion about the USA Freedom Act and the June 1st expiration of Section 215 of the PATRIOT Act. So Rainey, go ahead and introduce yourself, please, to our audience at home.
Sure thing. Thank you so much for having me, Jess. I'm really excited about this Google Hangout. And so my name is Rainey Reitman. I am the activism director of the Electronic Frontier Foundation. I've been here for about 5 years now, and I work on issues related to surveillance, privacy, a little bit of software patents, and a lot related to how your data is affected by current laws and current policies. So very much a geek when it comes to privacy and surveillance issues. The Electronic Frontier Foundation is a nonprofit that's been around for more than 20 years now, and we focus on the intersection of technology and civil liberties. So many people are very familiar with issues like free speech and privacy, your First Amendment, your Fourth Amendment rights. And our organization is really focused on how are those rights affected by new technologies. As more of our lives become increasingly digital, how does that present new and perhaps very novel threats to those basic rights that we had come to expect in the offline world? Should I go on and talk a little bit about PATRIOT Act, or should I let Robyn introduce herself first?
Let's have Robyn introduce herself, and then we'll come back to you, and you can dive into the PATRIOT Act.
Okay.
Great. Thanks, Jess. And thank you again for having me on. I'm also very excited about this Google Hangout and about all of the reform that is likely to come in the next month and that hopefully will come in the coming years. So my name is Robyn Greene. I'm a policy counsel with New America's Open Technology Institute. I've been there for about a year now working on surveillance reform and privacy issues in general, also having to do with cybersecurity information sharing and internet security in general. And before that, I was working on those same issues for 3 years with the ACLU. So I've also been in this field for quite some time, and am quite a privacy and tech wonk as well. The Open Technology Institute is an organization that works not only on surveillance reform and cybersecurity issues, but we're really committed to ensuring that the public has open access to internet and wireless communications technologies everywhere. To meet the end of our mission, we work a lot on net neutrality issues, on internet governance issues, on other kinds of internet security issues such as encryption and CALIA, and we do a lot of work on international cybersecurity issues as well.
Great, thanks, Robyn. So yeah, Rainey, I'd love if you can give us a current rundown of the state of play and the PATRIOT Act, and especially, why is June 1st such an important day?
Oh, I'm so glad you asked. So just a little brief history lesson in case people don't know. Right after 9/11, Congress passed an enormous bill that had a lot of different provisions in it, known as the PATRIOT Act. And the debate we're having now is really honed in on a particular section of that bill, known as Section 215. This is a section of the law that said that the government was able to collect tangible things that were relevant to an authorized investigation. Now, it turned out that there was a secret court, it's known as the FISA court, the Foreign Intelligence Surveillance Court, which is set up to help govern some of our surveillance practices. It's basically designed as a fail-safe to make sure that the NSA doesn't run haywire collecting more than they should. But it's a very interesting court because unlike most courts that have a defense attorney and a prosecution meeting and presenting their arguments, this is a court that is held entirely in secret. It's just the government and a judge. And this court interpreted that section of law, Section 215, as allowing for the mass surveillance of everybody's phone records. This became very public right after Edward Snowden first came on the fore. In fact, it was his very first leak, was a secret document from the FISA court authorizing the mass surveillance of all of our phone records. And that means every single time that I call my mother, that's logged and that's sent over to the NSA. And the authorization from the court was for a 3-month time period, but we found out that that particular order was similar to orders that were being given to other telecom companies, and also that it had been going on for 7 years. So this was a pretty big moment, and it reignited this conversation about, is this appropriate, is it necessary, and is it even legal? EFF and many other organizations have argued that this is not a legitimate interpretation of the PATRIOT Act, that when you say that you can collect records for an authorized investigation, you really can't make an argument that every single phone record is relevant to an authorized investigation. So that was one of our arguments. And now we are in this really interesting time because Congress put these very important safeguards into the law, especially around Section 215, and it is designed to expire. Because it was such an expansive power when they first enacted it, they weren't sure they wanted to keep it in the law forever. And so they said, let's make sure the thing expires every few years and we have an opportunity to debate and decide whether to renew it. And that section of law, Section 215, is going to be expiring on June 1st of this year, which means Congress has a couple of opportunities. They can choose to renew it exactly as it stands. They could choose to just let it sunset, do nothing, and let the bill expire. Or they could decide to enact some form of reform legislation that alters the powers that have been granted to the government to engage in surveillance. And that's where we all are right now. And that's why literally the next couple of weeks are going to be momentous in the surveillance reform debate.
Great. Thank you so much, Rainey. That's a great overview. And I forgot to mention, if you're watching the live stream, we have the Q&A app running, so you can submit questions there. I have a list of questions that I'm ready to ask, and I pulled a few comments from the G+ event page as well. So we'll try to get to as many questions as we can. So thanks, and please submit, and we'll do our best. So Robyn, can you talk a little bit about USA Freedom and sort of what that means in light of everything that Rainey laid out as the background?
Yeah, absolutely. So USA Freedom is a bill that has actually been around for quite some time now. It was originally introduced in October of 2013 in response to the Snowden leaks, particularly the disclosure that Rainey was talking about, where we learned that the NSA was collecting Americans' phone records metadata in bulk. And so the bill had been structured to address 3 significant surveillance authorities: PATRIOT Act Section 215, the FISA pen register and trap and trace device authorities, which I'll explain in just a second, and also national security letter authorities, which I'll explain in just a second. So the bill was developed to rein in those authorities to ensure that abuses could no longer happen under them, and then also to provide reforms to the Foreign Intelligence Surveillance Court so that there could be more oversight, more of an adversarial process, so that it wasn't only the government advocating for their own reforms, and then also to add transparency reforms so that Congress could better oversee the intelligence community's surveillance activities, so that the public could better oversee it, and so that companies would be able to more publicly report on the types of surveillance demands that they were receiving. So that bill kicked around for a little bit, but it didn't wind up getting taken up until actually May of 2014 when the House Judiciary Committee approved it. The bill had been significantly weakened from its original text and really just changed altogether in terms of the mechanism that would have enacted the reform, but it was still called the USA Freedom Act. And then after the House Judiciary Committee unanimously reported it out of committee, and the House Intelligence Committee unanimously reported it out of committee, House leadership watered it down through a procedural loophole and then put it on the floor for a vote. It passed the House. But because it had been so significantly watered down, privacy groups and companies withdrew their support, and the Senate wound up taking that bill and reinserting a lot of the reforms that had been lost, so beefing back up those reforms. Groups overwhelmingly supported the bill, and in fact, it got 58 votes in favor of it on a procedural vote in the Senate, but unfortunately, because of Senate procedure, it needed 60 votes to continue, and so it wound up dying last Congress. In response to that, this Congress, we've picked the bill back up. House Judiciary and the House Intelligence Committee worked together with leadership to craft a negotiated deal that maintains many of the strong reforms, particularly the strong bulk bans on bulk collection and some of the transparency reforms that were included in last summer's Senate bill. But we are still waiting to see what happens on that. It's actually likely to come up for a vote tomorrow. The House Judiciary Committee reported it out, approved it 25-2, and the two dissenters were actually voting no because they didn't think it went quite far enough in terms of reform. So I just want to talk a little bit about what exactly the bill is going to do, and then I'll sort of kick it back to you guys. So in terms of the reforms, what it does is it says that the NSA can no longer collect Americans' phone records and other tangible things under Section 215 unless it uses a specific selection term, which it defines narrowly enough to ensure that it has to be reasonably targeting someone associated with the terrorism investigation. So this means that you can't be collecting all the phone records developed, in the country on a given day. You can't do a collection of all of the records that are created in a state or a city. There need to be more specific targets for the collection, and those targets have to be associated to a terrorism investigation. In addition to that, it extends that restriction to collections under the Pen Register Authority of FISA, which was actually used up until 2011 to collect internet metadata in bulk. So this is really important because what we've seen is the government's willing to shift the bulk collection programs through different authorities. And so everything needs to be reformed in order to ensure that there is an effective ban on bulk collection. So that for the same reason, we're instituting the same, or Congress, would be instituting the same ban on bulk collection under national security letter authorities with USA Freedom Act as well. Then the next thing it does is it increases transparency. It does this in a few ways. First of all, it significantly increases government reporting on the different types of national security processes it serves to companies, on the amounts of information it's receiving, on the number of targets it's seeking information on. And it's doing this by breaking out the number of requests it's doing for many of these authorities. In addition to that, the Foreign Intelligence Surveillance Court, anytime it were to issue a significant or novel interpretation of the law or authorize some new type of surveillance, the Director of National Intelligence would have to release a redacted version of that opinion, or the Attorney General would have to release a summary that would give the public an idea of how the FISC was interpreting the law. So, for example, if the USA Freedom Act passed and the FISC had interpreted it in a way that wasn't really faithful to the intent of Congress, we would now have the opportunity to know about that, whereas pre-Snowden leaks, the bulk collection program went on for years, and even Jim Sensenbrenner, the author of the PATRIOT Act, didn't know what was going on. So that would be an incredibly important reform. The third type of transparency that would increase is where companies could report on the types of informational requests that they receive from the intelligence community. Then the other kind of reform is the Foreign Intelligence Surveillance Court reform, where an amicus would be created, actually a panel of 5 amici. These are friends of the court, so they're people who will be providing assistance to the Foreign Intelligence Surveillance Court anytime there is a significant or novel case, and they will be responsible for either advocating for privacy, giving technological advice or expertise, or advocating on other relevant issues to the court.
Great, thank you so much, Robyn. So something that we also wanted to make sure we address is, I'm going to just read the question from the Q&A app, actually. So with reforms to Section 215 contained within the current version of USA Freedom effectively address the Second Circuit Court's ruling that 215 doesn't actually authorize bulk metadata collection? So I think, addressing the specific answer there, and then talking a little bit about that Second Circuit Court ruling and kind of what that means in the context of USA Freedom.
So I can talk a little bit about that, and then Robyn can just jump in if you have anything to add. So the Second Circuit just ruled on one of the ACLU's cases. The ACLU actually went to court to argue that the bulk collection of phone records violated the Constitution and violated the statute, actually violated the words in the law of the PATRIOT Act, Section 215. And the Second Circuit had a really remarkable decision that just came out last week, which was extremely important also because it sets up the debate in Congress differently. But the Second Circuit said, first of all, that ACLU had the right to sue over this. If you look historically at a lot of these NSA surveillance cases, we, including EFF, have gone to court many times and argued about this issue, and the government has made the argument that even if we have individuals whose data is affected, they don't have standing. They don't have the right to sue in court. So the Second Circuit recognized ACLU's right to sue over this. EFF served as amicus, and so we also, were able to contribute to this. And second, they said that the phone record surveillance program violated the law, that Section 215, written by Sensenbrenner, and was never intended to be something that would allow the NSA to sweep up everybody's phone records. And that's huge. That basically means that all of these years, the NSA, the courts are recognizing, has been violating the law, that they should never have been able to do this. And the court did not touch on the question of whether or not this also violated the Constitution, because many people are like, well, what if Congress goes back and changes the law, and they say that they can do this? Wouldn't it still violate the Constitution? Doesn't it still violate our First and Fourth Amendment rights? And the court decided not to take an opinion there, but said that the issues were very complex with regards to the constitutional concerns. And so because they were so serious, they wanted to rule on the statutory issue, and then potentially there's the opportunity for them to revisit the constitutional issue. And this is really important because it shifts the debate in Congress in a way that's very powerful. It makes it much more likely that Congress will want to do something to pass a reform bill, because the opportunity for Congress to simply reauthorize the PATRIOT Act in exactly the same way it had been before has diminished, because we see that if Congress tomorrow said, well, we don't want to have this debate, we don't want to move this reform forward, we're just going to pass the exact same reauthorization of the bill that we had previously, we're going to continue with the PATRIOT Act for another 3 years, then the Second Circuit would say, actually you can't, because the programs that you have in place now violate the law. And so all of a sudden Congress has to do something else. If they can either stop this program entirely or pass a stronger reform bill. And so this has been a really momentous thing to have happen, because it's right on the cusp of this debate, which sets up surveillance reform advocates in this incredibly powerful position to negotiate for something stronger, for better reforms, and for the opportunity to really see something happen in the next few weeks. Do you want to jump in, Robyn?
Yeah, I think at OTI, we agree that it was absolutely an incredible decision, and it's momentous, as Rainey said. It's something that's really going to help to push the surveillance reform debate further. We support the USA Freedom Act because we think it's going to make really meaningful reforms. In the House right now, I think the timeline is really short, and as I said, there's a really delicate negotiation that went on between the leadership in the House and the relevant committee chairman. And so this vote's coming up tomorrow. It's not clear whether there's going to be opportunities for amendments, but we would certainly love to see amendments that would help to strengthen even further the privacy protections in the bill. As we turn to the Senate, though, I think that this is really going to create opportunity for us to make that strong argument that there should be amendments. But, the truth is it's still a really uphill battle in the Senate. Senator or Majority Leader McConnell has made a lot of statements that he still wants to reauthorize Section 215. We agree with Rainey. It's not clear that there is going to be the authority to reinstitute the 215 call detail record program, the bulk collection program, even with a straight reauthorization. It's something that would likely be litigated, and it's going to continue being litigated in 2 other cases and could make its way up to the Supreme Court But all of that could take years to happen, and so right now it's really important that we focus on enacting reforms that are going to help protect Americans' privacy, and make sure that the Senate in particular understands that the status quo can't continue. It can't continue legally, it can't continue economically, it can't continue from a privacy perspective. American constituents don't want it. The House certainly doesn't want it. I think we'll learn that loud and clear tomorrow. And we need everyone who's watching this Hangout to reach out to their representatives and to their senators and make sure that those members of Congress know that you don't want it either. Because it's an uphill battle, even with all the headwinds that are going in our direction. We still have a lot of work to do.
And let's just take a sec to talk a bit about timing. So I think that it seems like Senate outreach is going to be a big push. Of course, we have to get through the House vote first, and so I know that people who are watching may want to be interested in how they can get involved. And so we are going to be, as we get closer to the Senate vote, we'll be providing updates through the Take Action mailing list. And I'll provide the email address for that at the end of this call, so you can sign up there and find out what's happening. But can you, either Robyn or Rainey, what do you feel like is the sort of the timing that we're looking at as these things move?
So the House is expected to vote tomorrow, and I think it's possible the Senate could take it up right away, or it's possible they sort of bide their time and wait to the last minute. It certainly would trend with history if they waited until the last minute. I hope that they don't do that, though. Right now, the deadline that we're looking at, while the authority doesn't expire until June 1st, Congress is recessed for the week before that because of Memorial Day, so they're not even around to vote on a bill. Which means that really May 21st, May 22nd is the deadline, unless the Senate does push through a short-term or I hope not a long-term reauthorization. Then Congress would reconsider it. I think one of the most important things, though, is going to be making sure that everyone who cares about this issue makes clear to their senators and to their representatives in the House that they won't stand for even a short-term reauthorization. A day would be too long, let alone a month or a few months or a year. What that would signal is an effort to negotiate down from reform, not an effort to strengthen reform. And so any kind of reauthorization would be a huge, huge problem. Right now, it's just do or die. The Senate's got to pick this up, and they've got to hear from their constituents and make sure that those members of Congress know that this is something that voters care about.
I would just second that. I think that if we look historically at what Congress tends to do is when they have this sort of looming deadline, sometimes they'll try to buy themselves more time. They'll be like, well, let's just reauthorize this for 3 months and push this out a little bit. And that's really an opportunity, I think, for them to try to avoid getting a lot of public attention. But we want a lot of public attention to this issue. Americans are frustrated with this program and frankly frustrated with the NSA. And this should be the beginning of a larger reform conversation. So I really think that we need to push Congress to not reauthorize this, even in a short-term extension. We're running a campaign site, fight215.org, so fight215.org, and we have a phone tool set up there so that people can actually enter in their number and be connected directly with their members of Congress, and then urge them to push for strong surveillance reform and stop any reauthorization of Section 215 of the PATRIOT Act. And that's really important for people to do. I have heard numerous times the power of phone calls to affecting members of Congress. When their phone lines are ringing, they notice. They pay attention when their constituents call. So it really can make a huge difference, as we saw with debates like SOPA and things like that. So this is really the key moment to do it, and this is the week to do it.
Awesome, thank you. And we have just a few minutes left, but I wanted to. There are some questions that are related to the collection, and questions about phone metadata versus internet metadata, and then what happens to data that's already been collected. So can you talk a little bit about, so we've talked a lot about phone metadata, but sort of what is the future? How do any of these changes impact internet metadata collection and other types of bulk collection?
So one of the keys to the USA Freedom Act is that it doesn't just address the phone records collection program. It would address the Internet metadata collection program that was operating under the Pen Register Authority, though it stopped. So all of these types of information are just incredibly, incredibly revealing to individuals' personal habits, to their thoughts, to their interests. As Rainey said, if she called her mom, the NSA would know about it right now. And that just shouldn't be the case. There is no reason that the NSA should have that kind of information about everybody. So in order to address that, the USA Freedom Act is that first step. There is more comprehensive reform that will be needed after the USA Freedom Act passes. But right now what this does is it addresses these core domestic collection programs so that the bulk metadata collection can no longer operate under the PATRIOT Act Section 215 or 214 Pen Register Authority, and that it can't be transferred to national security letter authorities. Once it passes, though, we've absolutely got to train our attention on reforming Section 702 of the FISA Amendments Act, which has been used for bulk collection of Americans' internet records and internet communications and activities, and certainly to surveillance and computer operations operated under Executive Order 12333-12333. Those two authorities have been used for absolute bulk collection, really, of worldwide communications information. But we've got to build that momentum. We've got to take care of this problem first, and then immediately turn our attention to that next problem. But I worry that if we don't actually achieve meaningful reform with regard to Section 215, it's going to be a lot harder to make the argument to Congress that they should be reforming Section 702 and Executive Order 12333 collections.
Yeah, we've been of a similar mindset. There's a lot of different theories about how you could go about affecting change in Congress, and one of our operating theories, at least with regards to this particular debate, is that a victory on this can lead to victory on other things. When we look at the problems we've been facing with surveillance, NSA surveillance, EFF has been in active litigation against internet surveillance by the NSA for many, many years. We've been fighting this in the court systems, and we've been fighting it tooth and nail. And so for us, there was a real moment where we were like, hey, this USA Freedom Act is only going to touch this one issue, which is, well, and some other issues, but it's primarily going to be working on Section 215 of the PATRIOT Act, but there's all these other sections of law that need to be fixed. And so we don't see this coming debate around phone surveillance, phone record surveillance as the end. We see it as the beginning, that we will move forward to address the phone record surveillance program, and then from there turn our sights directly to internet surveillance. The specific authorities that Robyn just mentioned, Executive Order 12333, which was authorized by Ronald Reagan and has been a plague on our internet privacy ever since, and Section 702, which they're arguing gives them the right to engage in mass internet surveillance. So those two issues really need to be fixed. And frankly, if we really want to get down to the heart of this problem, so many of these programs have been allowed to exist because of issues with our broken transparency system. Our government has been trying to argue that they have the right to engage in surveillance without telling the public about it, shielding both their interpretations of the law from the public and their programs from the public, which meant that we relied on whistleblowers to shed light on these issues and then prompt the public conversation that we're having now. And it shouldn't work like that. We ought to have a government that's actually responsive, accountable, and transparent about what it's doing, so that we as a society can decide whether or not that's what we actually want the government doing on our behalf, because this is a democracy. So yes, we need to fix the surveillance programs, and especially the internet surveillance programs. We also have to think about long and hard about how we're going to address transparency and government accountability overall.
Yeah, I strongly agree with that. One of the things the USA Freedom Act does is it helps to enhance the transparency mechanisms and government accountability mechanisms, but there is still more work to be done afterwards. It's not only with regard to public reporting, but it's also with regard to making sure that the government can't abuse a state secrets privilege to to shield itself from litigation in the courts. That's been one of the major obstacles that groups like EFF and the ACLU have faced when trying to litigate these issues. Even after whistleblowers disclose information about abuse, it just goes nowhere in the courts. And so it really is left to Congress to deal with this. So we've got to get this first thing done. We've got to get USA Freedom Act passed, and then we've got to move on to the next big chapter.
So it sounds like this is really just sort of the first 5 miles in a much longer marathon.
Oh yeah, it's an ultra marathon, but we're all well trained, so.
Awesome. Well, thank you both so much for joining us today, and thanks to everybody who was watching and submitted some questions. I'm sorry that we couldn't get to everything, but hopefully we addressed them at least thematically. And so, June 1st isn't that far away. I mentioned that we have a website that you can visit to sign up to get updates, and that is google.com/takeaction. I'll post that on the G+ event page as well. And then you can also check out fight215.org for more information on what EFF is doing. And then, Robyn, do you have, is there a particular place where people can go to check out what Open Technology Institute is up to as well?
Yeah, absolutely. So you can check out www.newamerica.org/OTI, and just we've got lots of different papers and press releases, articles, comparison charts, you name it. You should also just feel free to tweet at me with questions, and I'll be very active in responding to you and providing resources. So my handle is @Robyn_Greene, ROBYN_GREENE. So tweet away.
Awesome. Thank you so much, everybody, and we're going off air now. Have a great day.
Bye.
Bye.